This is Bob Damewood. I'm a staff attorney with Regional Housing Legal Services. I'll be leading off this presentation, but I just want to point out that in addition to myself and Eileen Yacknin, Kevin Quisenberry is also presenting with us. I'm going to give a quick overview of receivership, what it is, how it works, and I'll quickly talk about a case, one of my cases where a resident association successfully used receivership to preserve their manufactured home community. Eileen Yacknin will then talk about a case that she had, a habitability and code enforcement case that she had where ownership was in dispute and receivership was used with what I would call mixed results. And then Kevin will lead a discussion on, the lessons learned from that case, which Kevin and I, assisted on, and provide some practical advice. And then we'll answer questions, or we can also answer questions throughout. Okay, so for a quick overview, like I said, I'm a staff attorney with Regional Housing Legal Services. Hopefully everyone knows what RHLS is. We're a statewide specialty program within the plan network, and we focus on affordable housing and community development. So what is a receiver? What are we talking about today? A receiver is a person appointed by the court. So, generally a third person, not a party, appointed by the court to take temporary possession, management, and control over a property or a business in order to protect some recognized legal right. So they essentially step into the shoes of the owner and manage the property. The purposes and powers aren't uniform. They're basically they're described in the receiver order, the order appointing the receiver. And it's not unusual for the receiver to draft that order. Usually, so this is a remedy that was kind of developed by creditors and shareholders and business partners, back in the day, to protect the value of their asset, right? So to prevent a business from being mismanaged, or prevent a business, property from being dissipated, where they had an ownership interest or a lien. Receivership is what's called an extraordinary equitable remedy. So it is, it's similar to a preliminary injunction, but courts describe it, opinions that have considered whether it's an appropriate remedy, describe it as extraordinary, as something that the courts will only do in extraordinary circumstances, because it's in derogation of property rights. And everyone, I'm sure, knows how sacred property rights are in our legal system, right? And so when you're taking someone's property away from them and taking it out of their hands and putting it into the control of someone appointed by the courts view that as an extraordinary thing to do. But so basically, there's case law saying that a receiver will only be appointed where the right to appointment is clear. Basically, where the person petitioning for a receiver can show that the appointment is necessary to protect a clear legal right, where whoever's motioning for it shows that irreparable damage will likely result if a receiver is not appointed, where it won't substantially injure or interfere with the rights of other entities with an ownership interest or a lien interest in the property, and where greater damage will result if a receiver is not appointed than if a receiver is appointed. The other thing about receivership to keep in mind is the relief is ancillary. So you can't file a complaint for appointment of receiver. That can't be the sole relief that you're asking for. There has to be some kind of cause of action, some kind of relief requested beyond, other than asking a receiver. And then once you, so, in a habitability case, for instance, if you file for monetary damages or for injunctive relief, then you would file a motion, for ancillary relief for the appointment of a receiver. And then the rules governing appointment of receivers are at PARCP 1533. There's no statutory provisions that I'm aware of governing appointments of receivers. There's a couple cases that we found in Pennsylvania. I mean, first of all, in other states, receivership is a much more common remedy in habitability cases than in Pennsylvania. It hasn't been used very often in Pennsylvania, and I'm not sure why that is. But there is precedent for it in Pennsylvania, and so the one, I guess the best case to cite would be Borough of Kennett Square. The citation is on the slide. Basically this was a code enforcement case regarding a multifamily property where the code the code officers weren't getting anywhere, and they just got frustrated and decided to request the appointment of a receiver to take over the property to fix the health and safety problems and bring the property to code. The property owner, challenged that, and the Commonwealth Court, both the trial court and Commonwealth Court, agreed that it was appropriate. But the Commonwealth Court specifically cited the reason, saying it's appropriate where the health and welfare of tenants was endangered, and code enforcement actions. So there's no remedy at law, right? Code enforcement actions were unsuccessful. And so if you're going to be requesting a receiver, this is a good case to keep in your back pocket. And then there's another, there's a DNC case in Philadelphia that involved a commercial property where both the landlord and the tenant were in dispute over who was responsible for making repairs, and the court on its own just appointed a receiver, saying, look, this is a danger to the public and someone's got to fix it up, so I'm going to appoint a receiver and make you two pay for it. Okay, so Eileen and I are going to talk about the cases where we used receivership. The one I'm going, and the citations are here. We'll both share pleadings, but if you want to look for them yourself, here's the docket information. The case I'm going to talk about is DEP versus Schlafke et al. And in that case, a resident association was appointed as receiver to manage the community water system in their manufactured home community. It was a DEP enforcement action against the owner. And so now you're stuck with my face. I apologize for that, but very quickly I'm gonna talk about that case. So DEP versus Schlafke was, it involved a 91 lot mobile home park in Crawford County outside of Conneaut Lake. 91 units, almost half were privately owned. So the owners and prior owners are selling off lots to individual residents. So ownership was a little bit complicated, but there were 49 units owned by the company, by Schlafke, the LLC that she created, and 42 privately owned. Most of them were on a community water system, but not all. So, basically the DEP filed an enforcement action in October 2012 against Schlafke and her LLC based on failure to do water quality testing and based on illegal dumping. They filed a petition to enforce their administrative order with the Crawford County Court of Common Pleas in November of 2012. Shortly after that, in early December, the owner abandoned the park, instructed the water company to terminate water service to the common areas, which basically were the streetlights and the pump house for the water system, and so that deprived the residents of water. The residents passed a hat, and one resident got the water restored in their name, and they started paying the bill. So they got the water restored. And then another resident got trained up on how to manage the water system. Basically how to treat the water, how much chlorine to put in, what testing to do on a daily basis to make sure that that it's safe to drink. And so they just stepped up and started managing their own water system. And personally, I love cases of tenant self-help, and we got a chance to support that. So they reached out to us and asked for our help. In early January of 2013, DEP, to their credit, filed a motion for extraordinary relief, asking the Court of Common Pleas in Crawford County to appoint a receiver to manage the park. Basically the Safe Drinking Water Act, states that violations are a public nuisance, and it gives DEP the right to, or the authority to proceed in equity. So they use that equity power to request the appointment of a receiver. There was a hearing on that motion on January, later in January, January 21st, 2013. No receivers stepped forward. No one was interested in taking over operation of the water system. And so, the resident association was there. I was representing them, and, we raised our hand and said, the resident association will do it, but first we need to, raise the money to make sure that the association can get back into compliance. We didn't want to be out of compliance on day one with no ability to get into compliance with the Safe Drinking Water Act. So the court gave us time to do that. We went to Pennsylvania Housing Finance Agency, and they were willing to give us, give the association a small forgivable loan, $35,000 forgivable loan, to cover health and safety issues and some, some due diligence that I'll get to in a minute. But they wouldn't give it to a fledgling resident association automatically, by itself. So we had to find an intermediary. We had to find a more established nonprofit to take the loan. And we eventually did talk to a group called Pathstone. They accepted the loan in mid-May 2013, and we informed the court, and got the association was appointed as receiver in June 2013. And in the meantime, we got them incorporated and helped them with bylaws and things like that. The appointment of receiver, the judge, and maybe why no one was interested is the judge was reluctant to appoint someone as receiver to manage the whole park. So it was limited to managing the water system itself. But the judge left it open to, for the resident association to come in and request an expansion of that power, which we did a couple months later. To managing the whole park, where we could make the case that there were other health and safety issues going on and no one to address those. And then, the other thing that the judge deferred in the original order was compensation, and we filed a motion to do that, and we got an order directing the owner of the park to compensate the resident association members for their volunteer time and to compensate RHLS for the value of our legal expenses, or legal time, which was greatly reduced, but that added up, and I'll get to that in a minute. So in January 2014, the judge entered those orders expanding the receiver powers, awarding compensation retroactive to the date of appointment. And then in the meantime, from the time, the original time, from the time the association was appointed receiver in June 2013 until the park was sold on April 24th, 2015, the resident association used the $35,000 that they got from PHFA, to address health and safety issues, so to perform all the backlog and water testing, to bring the park into compliance with DEP, with the Safe Drinking Water Act, to repair the pump house, to replace broken sewer lines, and to clean up the illegal dumping. They also used some of the money for a capital needs assessment because they wanted to acquire the park. So an investigation of what are the short-term and long-term repair needs for the park. So the cost of doing all of that, not the due diligence, but the health and safety repairs, plus the compensation that was ordered, we were able to get that liened against the property in first lien position in front of taxes, because there's pretty good case law that says that receivers get paid first. They get paid before creditors. And so anything that it's unpaid by the operating income or by the owner of the property, it can be liened against the property in first lien position. Well, the property was exposed to an upset sale before the appointment of receiver happened, and there were no purchases. This is in Retzel County, and so that set it up for the ability of the Tax Claim Bureau to list it in for a judicial sale, a free and clear judicial sale. So we asked the Tax Claim Bureau to do that. They did so. The sale happened in April 2015. And as first lien holder, the homeowner association the resident association was able to bid up to the amount of their lien, and all they had to pay was transfer taxes and recording costs. And so, within the $35,000 that, there was about $10,000 left over from PHFA's forgivable loan, and they used that to pay the transfer taxes and recording costs, and now they own the park. So this is, a sort of an ideal situation. This is a successful use of receivership to preserve a manufactured home community and to acquire ownership. But I need to point out that the conditions were ideal for that to happen, right? And cases are not always going to be ideal. With that, I'm going to hand it over to Eileen to talk about a case that she had where the conditions weren't quite ideal for receivership.
Right, thank you. I work at Neighborhood Legal Services in Pittsburgh. We serve Allegheny, Beaver, Butler, and Lawrence counties, and this and the saga of this receivership story began in a small borough municipality just outside of the city limits, in a very low to moderate income neighborhood. But now that you got previewed in advance that my story has a little bit of a different outcome than Bob's. It reminded me of when I was in 8th grade and needing to do a science experiment for the science fair, and I decided to do it on to do hydroponics to see how my vegetables would grow in water instead of soil, and they all died. And so the title of my science project poster was "Why This Didn't Succeed," and that's what I feel I'm here to do today, is to explain to you why something doesn't succeed. But Kevin, I guess, can talk about that. I'll give you the anecdote first. So receivership was, I know I've heard that word before. The clients came to me, but it certainly wasn't on my mind when like probably a Friday around 3 o'clock or so, about 6 different clients, new people came into our office in those good old days when they did that, to say that the property in which they had been living in had been condemned by the Township of Penn Hills, and that they had all been given court orders to vacate within 24 hours. And they weren't as possibly polite as Bob's case clients, where they kind of like insisted on my help there. Where they all were living was in a multifamily, like 4 different units, 4 different 16, I believe, unit buildings, 4 different 16-unit buildings in the same area, all low. The rents were rather low. Many of the people there did not have any subsidized housing, and those who did have subsidies was voucher Section 8 subsidies. Among my clients were people who, some of whom told me that they had lived there for more than 15 years. Others, much more recently. Some had Section 8 and some did not. But the reason the property was condemned was, as Bob suggested, is that the property itself, there was a huge mortgage on the property. There was a foreclosure action on the property. And after that occurred, there became a huge, unbelievably complicated challenges to the sale of the property, who the new owner of the property would be. And that was repeatedly, issues involving that litigation were repeatedly brought to the Superior Court, holding the whole outcome up for a long, long time, even before these clients came to legal services. And at one point, and at the point where shortly before they came to us, the lender, the plaintiff in the foreclosure proceedings, in the challenge foreclosure proceedings, who was then at that point saying, we're no longer the owner, there was a new owner, but that was being challenged by a third party, got fed up and unilaterally decided to contact all the utility company, contacted the electric company and the water and sewage company, the water and sewage being controlled by Penn Hills, and private Duquesne Light is our electric supplier in Allegheny County, and said, shut off the utilities because we're not going to pay for them anymore. Those were utilities that controlled electricity, controlled the common areas in the buildings, and the water and sewage was for all the properties. And so that was okay at that point for my clients. They figured out ways to address those problems on their own, not in the skilled way that Bob's clients did, but rather gerrymandered electric cords so that they could use their different people's accounts to keep the electricity on in the hallways and stuff like that, and get water from other places. But at the same time, the property was deteriorating significantly, and the borough of Penn Hills believed it was, and concluded that this was a terrible eyesore, that it was probably infested with drug dealers and squatters. And I'd have to concede that there probably were some of those residing in some of the vacant parts of those buildings. And Penn Hills was determined to close that property down and get rid of those remaining residents. So that's why they got involved and they issued this condemnation order. So immediately, my first response was to seek injunctive relief against the water company and the electric companies for violating the USTRA, and then I always forget the name of the parallel protective statute for consumers whose utilities are being supposed to be paid for by the tenants, by the landlords, by the owners, but using violations of those statutes to obtain injunctive relief against their immediate termination of those utilities, which formed the basis for the condemnation order at that point. And fortunately, we obtained a sympathetic judge at that point who entered an injunction against the immediate termination of those utilities. I then filed an appeal I learned that there are ways you can file appeals from condemnation orders of municipalities. I submitted an appeal on behalf of those tenants to stop the condemnation from proceeding. And so we obtained that order to stop those utilities. But I was not aware of all the legal challenges that were going on. All I knew is that my clients were then going to be ordered to pay the utilities forward, which which happened for a while, but didn't. And also, I had initially indicated to these clients that given the status of this foreclosure proceedings, I did not see how they would be able to remain indefinitely in the property unless, I mean, they weren't paying rent. They were, there's the people who had Section 8, the Housing Authority had learned about the problems with ownership disputes. And so the Housing Authority had stopped paying Section 8 subsidies to anyone because they had no idea who should have been the proper receiver of those subsidies. So these people's Section 8s, they were all told they were given vouchers. They all had to leave. They were supposedly have to leave as well. In any event, so I didn't know what to do because at that point we had to go. The agreement for getting the utilities back on was that they would have about 4 months before the utilities could be shut off. I had hoped that would give them enough time to relocate, but as I tell everybody I've ever supervised in terms of landlord-tenant law, when your client says they promise that they will be out by X date and they haven't yet signed a lease, I would put as much money as possible on a bet to say that they're not going to be out by the time that they promise. And that's exactly what happened. So then I was desperate, and Bob and Kevin came to the rescue. Bob, hot off of his case, said, "Hey, what about a receivership?" And I said, "Oh, okay, sure, as long as you guys help me as well." So the three of us, we then, so this was kind of curious to me, Bob, because I think I filed the action as a new docket number, not as an action related to the injunctive relief on the utilities. So I'm not so sure it really was ancillary to anything, except arguably it was ancillary.
Well, if I can interject, I know that, so we worked together on the complaint. I know the complaint asked also for, I believe, injunctive and monetary relief, raised some consumer protection claims. And so it wasn't just a complaint for the purpose of asking for the appointment of a receiver.
Okay.
That's mostly what we wanted, but there was, there was a monetary claim in there.
I see. So you were saying, so ancillary, there doesn't have to be you can raise the pending action in the same.
Yes.
I see.
Yes.
So that's what we did do. And I will have to tell you that the litigation concerning this receivership was the easiest litigation ever, because all we did was we asked for a receiver to be appointed to stop the condemnation and the removal of these tenants, and the respondent was the lender that had refused to maintain the property, and the petitioners, the plaintiffs, were our half a dozen clients, tenants. The reason it was such an easy proceeding, I mean, I don't know why, but in any event, what happened was that we obtained a judge, a president judge, who was very sympathetic even before COVID with the concerns about homelessness in Allegheny County. We had an initial conciliation conference in her chambers, and she said, "Fine, I'm going to issue, this sounds terrible. I'm not going to let these tenants be evicted. I'm going to enter an initial order, and you guys find a receiver, and I'll enter a receivership." And then she looked at the lender's attorney and said, "You don't have any problems with that, do you?" And that's essentially how the litigation went from then on. No litigation, all in the judge's chambers, and without any testimony at all, except at the very end of the case. So that was the very easy part. But then the second part was who's going to be in charge of this property. And that is something I'm sure Kevin's going to talk about, but as one of the big problems, because these tenants were not sophisticated in the way that Bob's clients were. They were not, they had, even though one of them had some organizing experience, they were not motivated to take any effort to try to organize the remaining tenants. And there were not, people were moving out around during the course of these proceedings, but they did not want to take ownership interest themselves in these properties, which really were deteriorating very badly over the course of the 2 years that we were involved in this case. But they wanted, one, a place to live, or two, at least a place to live until they could move out. So then we needed some other entity, and that was a big problem, because any person who would be a receiver was going to have, and this is, I think, a problem with this type of cases, that a receiver would have the responsibility to manage, to provide for all the repairs that would be necessary to make the place habitable, and would cost a lot of money and a lot of time. And we spent several hours trying to find somebody that might be willing to do that, perhaps a developer. In this particular case, by some sort of a miracle, we came up with it turned out that there had been another potential buyer initially in the litigation, who's also a real estate attorney, who had already approached some of the tenants, and he very reluctantly agreed that he would serve as the conservator. I'm sorry, serve as the receiver. So we went to court, and in the chambers we said, here he is. And despite the fact that there could have been a conflict of interest, the judge said, fine, you don't have a problem with it, do you, baby? They couldn't say anything. And then the next problem was, where's the money going to come to pay all these utilities, and pay for the garbage collection, and pay for security, because there were lots of squatters and people who probably shouldn't have been there. And in any event, Bob convinced Bayview, the lender, that any money that they put forward to help pay for the receiver would become a first lien on the property, that Bayview then would be protected by any money that was put out by them to help protect the property before the legal challenges were all resolved. And so the judge says, great, that sounds like a great idea. And for somehow Bayview was convinced that they would then pay $80,000 to this receiver to manage the property for until hopefully the issue of ownership was resolved. Maybe I'll leave it to, well, I'll see how much time I have. I will say that once our receiver, this real estate landlord against whom actually legal services lawyers have litigated tenant landlord cases in the past, was appointed, I will confess that there was an order that we required the receiver to make monthly statements of how this money was to be paid, how the money was used to pay for the necessary maintenance of the property. The receiver never did that. And we, mostly because at least from my point of view, it was not in my client's concerns, how the money was being spent. My clients' concerns really were to be able to stay there and have their utilities on, and while they were supposedly looking for new housing. But
And that was successful. I mean, you know, so it wasn't the result. I think we wanted to see kind of a preservation result, right? Us lawyers, but the clients, I mean, you know, they were able to remain in their homes for a lot longer than otherwise would have been the case, right?
ultimately,
So it's like mixed results.
yeah. So I'll stop there. So eventually what happened was that earlier in 2020, and my clients did live there for over a year and a half without paying any rent at all, without paying those utilities. And but then they ultimately, the challenges to ownership were resolved, and the new owner moved the court to require that all these tenants be vacated. And at that point, then Kevin proposed that we see if we can get some relocation money for those tenants, and for those residents who we knew we had reason to believe were actually legally on the property. We were able to get an agreement, again, in the same way, without any court hearing, really, except for being in chambers, to get Bayview to pay relocation, or actually the new owner to pay relocation money, a couple $1,000s a piece to these remaining tenants. So that's what happened, and the property now, they're probably going to tear it down. I don't even know what's going to happen to the property, but at least for my clients, they were able to remain there. And honestly, without this idea of a receivership, that would not have happened. Yes. So in that sense, it was a truly successful outcome for those tenants. I just want to point out that one of the tenants, it turned out I think we had very articulate plaintiffs in our case and people with sympathetic stories. But one of the guys who was like a very good organizer, very educated, seemed to me, he had told me a few months earlier that he had actually mostly moved out of his apartment, but he was staying there because he also wanted to be able to help with the litigation. But then we found out that, in fact, even though he still maintained the apartment he had been living in, I can't say the only person, the only being still living
Occupant.
in the apartment was his personal pet boa constrictor. And that's whom we were actually litigating the case on behalf of the boa constrictor. So anyway, that's my client's story, and Kevin is going to be able to tell the moral of the story to you.
Well, I'm sorry, if I can just interrupt quick. This is Kelly, and I need to launch the first of the CLE question poll boxes, so please respond now. Thank you, and please continue, Kevin.
Sure, thank you, Kelly. I'll add just a little bit more context to the case and then talk about, the lessons that we think that we learned through this. I'll say I had not litigated a receivership case either. I think all of us were aware of what it was, and were aware of cases in other places where it had been used, usually to try to preserve a property, so that it doesn't go under and so that all of the residents don't wind up being displaced. Of course, Bob had the experience, but a couple of other tidbits about this case. I had a couple clients come into my office independent from the clients that went into Eileen's office. They came to CJP a little bit later than they came to NLS. And so by the time we were talking to them, we learned, well, Eileen's already in court. She's already doing something, and by the time she got around to thinking about receivership and reached out to us, Bob and she and I put our heads together and decided to go forward, with that. But this property had 4 buildings. Each building had, I forget if it was 12 or 16 units. It was not a small development. The owner I'm going to call him the longtime owner, although I'm not sure how long he owned it. He had gone into default. The mortgage company was foreclosing. They had gone through the whole foreclosure process. There had been a sheriff's sale. The deed, had been given to the sheriff to go record. And the lender listed the property for sale through a real estate agent, and it went under agreement for over $1 million in cash by this, attorney real estate investor person. But before the sheriff could record the deed, the old owner conveyed a quitclaim deed to this new person, this third party owner, who came in and then tangled up the title and challenged, who was the rightful owner. And the third party guy, the new owner who came in, this was a business practice for him. He had done this in a number of cases where he convinced, a floundering owner to quitclaim the property to him. It was for $1,000 in this case. And then he goes around the property and starts knocking on doors and collecting rent, saying, I'm the new owner. And that's what he did here too. And it became evident to us over time that he had done this in a number of cases, and in part to sort of stall the ownership of the property, tangle up the title and run the thing down to the point where, the lender may walk away from it or let it go for a really attractive price. So, he was essentially trying to steal the property. He was trying to get a position where he had some legal claim of ownership, litigate that, tie everything up, collect some rent in the meantime, by the way. I don't know how much he wound up collecting, but for his $1,000 cash investment, he probably made like 10 or 100 fold, until tenants started refusing to pay him anything because they understood what was happening. But, it was that tangled title problem that we thought gave us an opportunity here to try to put a receivership into place until the legal title issue was resolved in the courts. And so that was the basic story, that we told to the judge. And so, to transition a little bit and talk about these cases more generally and talk about lessons that we learned in this case. Receivership, like Bob said, it really is an extreme remedy. Courts are very reluctant, to exert their power, their jurisdiction, to impose a receivership because they're taking away the core rights, at least for a period of time, that the property owner has. They're essentially telling the property owner, you cannot occupy and manage and maintain your asset. I'm going to appoint a third party to take away your occupancy, and management stewardship of this property. And courts are always reluctant to exercise equitable remedies, but my view is courts are especially reluctant to exercise this kind of an equitable remedy because it really does, interject into the rights of the purported owners in a really serious way. So in thinking about when this is appropriate, Bob said receivership has to be ancillary to some other purpose, some other ultimate claim or outcome. And that's totally true. The cases where it makes sense, I think, are cases where either you have a good shot at preserving that property, at the end of the game, where you have a property that's floundering because the mortgage is not being paid or conditions are deteriorating. But there's light at the end of the tunnel if you can turn it around or find a new owner to come in, who can turn it around. And so as, Bob and Eileen and I were speaking with colleagues around the country from Chicago, from California, principally, who are more in a habit of doing receivership cases. We were discussing this and they were telling us what they believed to be true. And I think we learned that it was correct. You really ought to have clear goals and an intended outcome, and work to make that happen and use receivership as a tool to get there. The receivership is temporary. By nature, it's a temporary remedy. The purpose is to preserve the asset and to prevent irreparable harm, including to people who may be occupying the building. And that was our, interest. Our client's interest was preserving their own housing, preserving the property, to the extent that was feasible, but ensuring that the garbage is collected and the utilities stay on and they're not involuntarily displaced, especially all of a sudden, which is where they were, when they first came to Eileen. Receivership is commonly used, like I said, in foreclosure or in bankruptcy cases. For our purposes, again, I think if we have and let me slow down. A receivership could be used in a single family home. You know, it could be used, you know, to preserve that asset and prevent irreparable harm to that tenant. I think more commonly it's used when you have, you know, a multifamily development where, you know, there are more interests, more people whose interests are at stake. But you're going to have to show, you know, this real imminent risk of irreparable harm and convince a judge that it makes sense, you know, to appoint the receiver. You know, but the third thing I'll say is you have to find a good receiver, and preferably you need to find the ultimate, you know, owner, you know, the preservation purchaser or party who's going to, you know, carry the property on after the receivership period. You know, a court may, for a period of time, appoint a receiver to allow tenants to leave in a orderly fashion and maybe with some assistance. I have my doubts if that is, you know, the story and the purpose of a request for a receivership. But, you know, if you can paint a realistic picture for the court where there's a real opportunity, you know, to preserve the asset with a new owner, or maybe with this owner if things can turn around. You know, that's where I think you'll get the court willing to participate with you. But you have to find that receiver, you know, who is mission oriented or, you know, profit oriented sufficiently. You know, in our case, you know, like Eileen mentioned, we had this purchaser. I mean, he put $1 million cash bid on the property. The offer was accepted. He put his hand money down, you know, and from his perspective, he didn't know about this third party purchaser until, you know, the litigation over the ownership erupted. But he was very motivated. You know, we began in thinking about who would we get for a receiver. Of course, we began by thinking about, okay, who are the nonprofit housing providers who we know? You know, Bob has relationships in the area with some nonprofit housing providers. I had some relationships too. You know, we reached out to a couple of those housing providers, told them what the story was, told them there's an opportunity here, you know, to maybe gain this asset at the end of the tunnel and, you know, renovate it and operate it. It's a pretty good location. The buildings, you know, at the beginning were not in bad shape. And we got turned down, you know, by a couple of folks. Another person was suggested to us who initially agreed to take it on, you know, property management company. He was an older fellow who owned the company. He was very nice, amicable. He agreed to do it. We submitted a proposal to the court to appoint him. And I think reality set in once he went out to the property and saw that, you know, midnight plumbers were stealing the copper out of some of the buildings. There were squatters, you know, setting up shop and living in the place. The garbage wasn't being collected, and he backed off. He bowed out, you know. And so that's when, you know, we went to this purchaser and said to him, "Look, you want the asset, you know, you're the one with an interest here to try to really preserve this thing. We think you're the right party, you know, to step in as a receiver here." And, you know, we told the story to the receiver that, you know, Bob had learned through his case, which is, you know, a receiver can add up all of their time, you know, and they can charge for that time, and they can put a lien on the property, you know, for all of that time. And that accumulates, you know. And so here you have a buyer, you know, who already has an interest in an agreement on the property. He wants it still. He can try to preserve the asset. The time and effort he puts into it, he can put, you know, as a building lien on the property and effectively reduce his purchase price, you know. And so he ultimately agreed to do it. You know, he didn't turn out to be the best receiver, and I'll talk about why in just a minute. But he was enough, you know, to get us to the point where we had that basic, you know, light at the end of the tunnel. And we had somebody who looked like they had real skin in the game and a motivation. But again, if you have clients coming in and, you know, they're in a property that's floundering and failing, and they're interested to preserve it or to at least preserve their own housing for a period of time, and you start to think about this idea of receivership, one of the first things you have to think about is who is going to be the receiver and what is the plan? You know, what's the ultimate plan that we can try to put into place for this property? If you can find nonprofit housing providers, you know, who are already in the business of managing, for instance, project-based Section 8 developments or, you know, low-income housing tax credit developments, I think those are ideal partners if you can find them. You know, the other key though is you're going to have money. You know, there's going to have to be money to operate the buildings in the meantime during the course of the receivership, all of the utility bills, garbage collection, maintenance, emergencies. There have to be funds, you know, to make it happen. Now, you know, a receiver, even though they can bill for their time and accumulate a lien, which may be attractive, you know, for some receivers. In our experience in this case, and I think generally speaking, that's not going to be enough, you know, and unless you really have a well-endowed housing provider who's stepping in and willing to spend their hard money to pay the hard bills. You're going to have money. You know, you're going to have the court order somebody to put the money up, you know, for the receivership. In our case, you know, the natural party, like Eileen mentioned, was the lender. You know, besides the purchaser, besides our receiver, who had a real motivation, you know, to be involved to make this work, the lender was the ultimate party of interest because they still had, you know, the mortgage and the ultimate lien on the property. And once the tangled title issue was resolved, the property was still going to come back to the lender first to then reconvey to some other buyer, you know, the receiver or maybe somebody else.
Kevin?
Go ahead.
Well, as I'm listening to this and thinking and reflecting, I think I probably would have still gone ahead with this receivership idea as the only way to keep these people in. But for practical purposes, for most of our clients who often have to deal with habitability issues, and often it's just a single family house that they're living in, and we try to say, and the owner's refusing to make the repairs, and we've thought, okay, maybe you can call the building code people, but we're concerned about calling building code people because then they'll condemn the property if it's so bad, and then the condemnation will require our clients to be removed. I'm thinking that if there are mortgages on these properties, then if we were to enlist the aid of the building code enforcers to condemn, and then prepare to file a receivership action against the owner, we might be able to get the lenders, if those homes are still mortgaged, to become those receivers for those properties. And maybe there is this more, it could be used more often in that kind of a situation than, you know, in addition to the situation where several tenants from a multifamily building come to face those problems.
Yeah, I think there are a couple of things. Go ahead, Bob. I was just because I think there are a couple of things in what you said that, you know, are right on, but go ahead, Bob.
And I agree. The only things that I think would concern me are, first of all, single family houses. You know, it was hard for us to find a receiver for a multifamily property, right? And it's a lot of headache, and you know, I just don't know if that would work for a single family rental property. And the other thing is lenders don't want to manage properties, right? Like they might ask for a receiver to be appointed to manage the property because then there's that distance. They're not going to be on the hook if somebody, you know, gets injured or what have you, or if there's any regulatory action taken, it won't be taken against them necessarily. So getting a lender to be the receiver, I'm not sure would work, but asking the lender to request the appointment of a receiver certainly does work. And I mean, Kevin and I did have another receivership experience with Wood Street Commons. If you remember that, Kevin, you know, and that was that kind of situation, you know, it was an affordable housing property that, you know, was in default. It was going to go through foreclosure, and the lender asked for the appointment of a receiver to take over management and to sell it to a responsible preservation purchaser, because the owner was just not really doing anything, not cooperating with any of that stuff. Yeah.
We weren't the parties requesting the receiver in that case, so I
Right.
didn't consider that, you know, as our receivership case. But in any event, let me pivot back just a little bit, you know, to pick up on what Eileen said. I'm going to pivot with it to say, you know, part of this is about building a team of people you know, or organizations, you know, who you can get to cooperate with you to make this happen. Who is the receiver? Who is that organization? Where's the money going to come from? If you can't get the court to order, say, a mortgagee or the property owner to put funds up, or if that's an impossibility, what third parties are there who may have funds that are available? Like Bob went to PHFA in his case to get funds for their purpose. You know, your state and local government may have sources. PHFA may be a source. CDBG funds could be used. Other funds could be used. Approaching the housing authorities, I think, is another good option, which is something we didn't explore in this case, and in retrospect, perhaps we should have. You know, but the couple of other things I'll say quickly in the interest of time are, once you get those pieces in place and you ask the court to do it, and the court says, yes, I'm going to appoint a receiver, you're still only a part way through. You know, you have to stay on top of this throughout the course of it. You know, in our case, the receiver was supposed to give monthly reports, and we let that slide for a number of months, and he did not give those monthly reports. He did wind up giving a couple of reports, you know, on how the money was spent, but it was later in the game. And in retrospect, we should have, you know, trusted but verified more with him about what he was doing and what was happening at the property. Because in reality, on the ground, you know, the midnight plumbers kept coming, and they would rip off the wood that he put up on the doors to barricade the place. You know, he put up fencing around the property. They would come through the fencing at night. You know, squatters, persons, you know, who had no legal entitlement to be at the property kept coming into the property. You know, and the receiver, he had a company and he had staff and he had some money, you know, but his resources were limited, you know, and we probably should have stayed on him, aware of what was happening, and stayed on him more, you know, to prevent the deterioration of the property. Because in our case, the legal title issue, the litigation over that, lasted so much longer than anybody ever anticipated. I mean, we expected this thing to go for some months, you know, and it went 2 years, you know, because it went on appeal and it came back down, and there were another new turn in development. You know, and so the last thing I sort of want to say is, in addition to trying to get to the end of the tunnel, you ought to make sure you're thinking about a plan B, you know, because circumstances can change over the course of a receivership. That's what we experienced in this case. You know, at the end of it, when the legal title issue finally was resolved by the courts, the money for the receivership had been exhausted, and the receiver himself had decided he's no longer interested. The property had deteriorated to the point where it wasn't worth his investment anymore. He was ready to walk away. He expressed that plainly to the court, that he was ready to be out. And at that point, the court said to all of us, look, I'm not going to force him to stay in here as a receiver. The conditions are deteriorating. They're looking bad and worse. The money that we've put in here has all been spent. I am reluctant to go back and make the mortgagee continue to put funds in, you know, without any prospect, you know, of getting this thing turned around. You know, and so the receiver and the court, and of course the lender and other parties, everyone was ready for this to end, except for our tenants, you know. And so at some point we made the conclusion that preservation of the property was not viable. We didn't have the pieces in place realistically to make that happen anymore. But, you know, we could still try to help our clients relocate with assistance and a time frame where they could try to, you know, land softly and not, you know, go through a traumatic, disastrous, you know, displacement. And so that's how we pivoted, you know, toward the end of the case. And the court went along with us for that too, you know, and the court did order, you know, that each of those tenants would receive funds and time, you know, to move. And then I'll just add a tidbit. Even after all of that happened and the new owner was in place and all of our clients got what they were, you know, awarded, there still were people who lived at that property. Some came to us and said, hey, I was a tenant, but you didn't include me. And we said, well, you know, we did everything that we could to identify who had a claim of entitlement as a tenant. Maybe we missed you, you know. And then there were still, you know, the persons who may have been squatters. And, you know, but who are we to say that? You know, if they're saying, well, I thought I had a lease. I had a lease with either the old owner or the new owner, this crooked third-party dude. You know, he did lease up some units. So, you know, at that point, we reached out again to, you know, some partners like there's a group that runs a program called Operation Safety Net. They're a homeless prevention outfit. They try to help tenants in crisis. They partner up with, the Red Cross and others. We brought them in, and try to connect them with those remaining households to help each of them develop some kind of a plan. We entered into negotiations with the new owner, to try to get money and time out of the new owner for those remaining residents, and said to them, look, if some of those residents wind up litigating with you, you're going to be stuck here sitting on this asset for time yet. And so the new owner was basically willing to give the time and was somewhat willing to give money. It turned out that, that wasn't needed and didn't happen because the assistance that folks were getting through the Operation Safety Net pathway, would be in jeopardy if they were receiving private dollars to cover the same purpose. But you ought to have a plan B in mind. Be aware of when you may need to implement it, but be ready to build it and put those pieces in place and move forward with that too. I guess that's all that I have to say about it.
This is Kelly. If I could just run the second CLE poll. Attorneys, please respond now. And Bob, please continue, or Eileen, or...
Sure. Well, I was just going to say, we're already past time, but if anyone has any questions, we'd be glad to take a stab at answering them.
Or call us when your clients come begging you to help them prevent being evicted by a condemnation order.
That too. I think all three of us are available to consult on cases. Kevin and I are both with statewide organizations, and we're available to co-counsel if needed. So,
absolutely.
So please, feel free to reach out to us if you have a case where it looks like receivership might be an appropriate remedy, or at least something that you want to explore. Please feel free to reach out.
And the one thing I wanted to add, in addition to that, I think all of us, we have these affordable housing resources in our communities. The HUD-assisted properties, the low-income housing tax credit properties. We need all of them. We really can't afford to lose any more of them. And so I have a particular interest, I think Bob does too, in preserving all of those properties, or at least the budget authority, the subsidy represented at those properties, when we can, whenever we can. And so I would say too, if you're aware of a building in your service area where the contract is expiring, or there's a foreclosure being threatened, or the conditions are significantly deteriorating, and it's putting that property and that subsidy at risk, reach out to us. Those are cases where receivership, makes sense. And on the preservation side, I think all of us should be really putting that, in our foreheads and thinking about, okay, we have to, as legal aid attorneys, figure out what we can do to help preserve the remaining affordable housing stock that we have in Pennsylvania.
Anything else?
And they all lived happily ever after. Okay.
Okay,
I'll tell you, our one client. Anyway.
Right. Go ahead, Kevin.
Thank you, Kelly. I was just going to tell Eileen, our one client, Andre, wants to play tennis. So he and I are going to go play tennis.
Oh, that's funny.
Thanks everyone for joining us. Thanks for joining us today. Bob, Eileen, Kevin, thank you so much for your time and for sharing this information with us. We appreciate it. And I'd like to wish you all a good rest of the day. Take care.
Thank you. Thank you.
Thank you, Kelly.